Good afternoon. Thanks for joining me this afternoon. Obviously, the oral arguments were heard in court today on our case against the governor to reinstate the legislative funding. We feel, again, very optimistic about our opportunities to get the funding reinstated. We feel very strongly that the governor's actions are unconstitutional and, frankly, just wrong. We negotiated this session in good faith with the governor. We agreed to all of the items that the governor now wants to change. He agreed to all of those items. And frankly, we don't think it's appropriate after the fact to try to go back and hold the legislature hostage in this sort of way. So we think the arguments went well today. Attorneys obviously made their points in court, and we will wait for a decision out of the court. And we feel confident that the court will decide in our favor.
Mr. Speaker, whose idea was the stipulation that was agreed to on Friday? Was that the governor blinking, or was this a mutual agreement?
It was obviously agreed to by both sides. I think none of us wants the legislative staff to go without funding, but we didn't create this problem. The governor did. We think it's absolutely inappropriate. We think it's inappropriate to use legislative staff in this sort of way to try to get legislators to renegotiate. So I think it was the right thing to agree to reinstate the funding for at least 90 days while the court works out the coming to a decision.
As a quick follow-up to that, does this just prolong this court battle potentially and the expense to taxpayers on both sides?
We don't think so. We think the court will move swiftly. Part of the stipulations were, in addition to legislative funding, that we would waive the ripeness issue and basically instruct the court that we are at an impasse and we're asking the court to decide this issue.
The judge mentioned a number of times that he would like the sides to get into mediation to find another resolution, and it sounded like the lawyers are saying that's off the table. Is that a correct interpretation of your stance on that?
Part of the stipulations that were agreed to were that the case is ripe. It should proceed and the court should make a decision. We also did let the court know in those stipulations that we are at an impasse. The governor apparently is not willing to give up his position. I think that's unfortunate. The 5 outstanding issues that he wants changed have all been agreed to. He agreed to them personally, and it's difficult now for him to, try to go back and renegotiate those items. So we feel like it's appropriate now for the court to intervene and make a decision now on whether or not the governor's course of action is constitutional, and we believe very strongly that it's not.
Mr. Speaker, a minute ago you said
about the stipulation. It does appear that the judge seemed to indicate that he's going to have to make some kind of decision on whether this is legitimate. He seemed to question whether that's something that he should even be doing. Is it your understanding that the judge has to basically sign off on this stipulation?
It is my understanding that that the courts would need to agree to those stipulations. My guess is that they spoke about that in court and talked about the stipulations. The fact that both sides in the case have agreed to those stipulations, I think, will help the court agree with them as well. But we are asking the court to decide this, and I think we both have agreed that we would like the legislature to have 90 days worth of funding while the court takes its time to make those decisions.
Just to follow up, basically the governor's attorney argued you guys started this with the poison pill in terms of the revenue department. And that it was actually analogous to what this line item veto. How do you respond to that?
Well, I thought it was interesting when the judge asked the governor's attorney whether or not our actions were illegal or unconstitutional, and the governor's attorney himself said no, they're not. They're absolutely acceptable. It is our right as the legislature to put bills on the governor's desk. We don't always have to take what the governor says. We can sometimes try to push the envelope, but our job is to get bills that the governor will sign. And we did our job, and he signed the entire state budget with the exception of the legislative funding. So we feel our actions were very appropriate. And based on the governor's actions since then, we think not only were our actions appropriate, they were obviously necessary, because the governor, I think, had every intent to veto again $650 million of tax relief for Minnesotans, and I think that's wrong.
Mr. Speaker, you said a couple minutes ago at least 90 days of an extension. So what happens on October 1st? Do we just keep on going, or is October 1st the real deadline, or is the next legislative session the real deadline, or what is the deadline?
Well, I think if the judge agrees with the stipulation and temporarily funds the legislature through October 1st, I think that gives them some time to try to work out the differences. At some point, If a decision hasn't been made, I think the courts would have to probably decide what functions of the legislature or are all functions of the legislature core functions that are essential state services. And I'll remind you that back in 2011, the courts did decide that the entire legislature was an essential service of state government.
Why not just do that right now? I mean, the judge seemed to say, the doctrine of judicial restraint, he says, why intervene if core functions can continue while political issues are addressed? Why not just ask the judge right now and forget the stipulation and ask the judge right now?
If the judge wants to declare the legislature, the entire legislature essential, we certainly think that would be a good decision and a win for us. That's obviously what we want to happen. What's interesting here is that the governor didn't veto the state government finance bill. He didn't veto the tax bill. What the governor did was line item veto funding for the legislature. He also, in his veto letter, did not say that he had any issue with the legislative funding. And I'll remind you that the level of legislative funding was exactly the same level of funding that the governor had in his proposed budget. So the governor didn't have any problem with the legislative funding. He's simply using the line item veto of defunding the legislature as leverage to try to get us to do something that he wants us to do. And I'm sorry, that's the part that makes this unconstitutional.
And his attorney, if I may follow up, his attorney argued in court that you guys just did essentially the flip side of that by putting the poison pill in. Why was that not the case?
Nope. The governor's attorney, literally in court, when asked by the judge, said that our action was neither illegal or unconstitutional, and we fully agree with him.
But he also said, did he not, that it was hypocrisy for you to argue coercion, given what you did with that poison pill?
No, because when we put the state government finance bill and the tax bill on the governor's desk, he still had his constitutional right to either sign those bills or veto those bills. And he exercised his constitutional right by signing both of those bills. And we knew he would do that. We believed that was the right decision. And by the way, the governor agreed to all of the provisions in those bills, including the 5 provisions that he now wants to change. So I certainly appreciate that the governor has changed his mind, but that's not my problem, and he shouldn't be taking that out on the good people that work here in the legislature. What he's doing is unconscionable.
A core part of the argument that the line item veto is unconstitutional is the issue of whether or not the governor objected to it. Now, the judge was skeptical about that, saying that a veto itself is a form of objection. Does that worry you does that undercut your case?
Well, no, it does not at all. Along with a veto, there is a requirement in our Constitution that you supply a veto letter stating what your reason for objecting to that particular item was. Not only does the governor not object to the funding for the legislature, this level of funding that he line item vetoed is exactly the same level of funding that he recommended in his state budget. So the governor is standing on very shaky ground. I think they probably know that. And we look for a very swift and firm decision out of the courts.
Mr. Speaker, the governor right now has a $150,000 cap on his legal fees. Do you have any cap on how much you will spend to continue pressing this case?
If we get a favorable decision out of the court this week, which we think that we will, and the governor does not appeal that decision, which frankly, if I think that the district court rules in our favor, I don't think the governor will appeal that decision. If those things happen, our bill will be far less than $150,000.
Are you expecting a decision, sir, this week on the stipulation part of it, or the whole ballgame?
It could be on the whole thing. We would appreciate a decision on the whole thing, but we expect at least on the stipulation.
And why do you think the governor won't appeal?
If he loses at this level, I think it would be bad for him to appeal and request something out of the Supreme Court. I think if I were him, I wouldn't appeal the decision.
Why would it be bad?
Well, I think you're cementing in a decision by the highest court in Minnesota that you can't line item veto the legislature's funding. Now, we think that's actually good. We think the Supreme Court will rule in our favor. But my guess is if the lower court does not rule in his favor, he likely wouldn't appeal. So just my own gut. You may have a different opinion. But
if you lose at the district court, will you 100% appeal to the Supreme Court?
Yes, absolutely, we will.
Speaker, what about the other case that was heard today regarding legislative pay, which seems to exist because of your unwillingness to support that pay commission's increase?
Well, I think what happened was Democrats passed this constitutional amendment and then passed enacting language that went along with it. What they didn't do was actually figure out how to pay the legislators. So they've put it onto my plate that I need to put a bill in the legislature that asks legislators to vote for their own pay increase. And that was what this whole thing was supposed to eliminate. Well, I'm sorry, legislators don't want to do that. And I didn't have the votes to pass a bill to increase the pay in the legislature. I asked Democrats if they wanted to put up votes. They kindly said, nope, we don't. So I didn't have a choice. I didn't have the votes to pass a pay increase. Why am I telling you all this? Because Democrats didn't do this the right way. If their intent was that the decision that was made by the electorate on the ballot would have been a binding decision, they should have supplied some funding or some language that would have directed how that funding would have taken place. They did not do that. So what we'll get here, if we lose, is the court will order us to do it, and that will supply the funding for the pay increases without members having to vote for it.
So, okay. You don't think you...
That was a pretty complete answer. If you want more, I can give you more.
You
But
don't think you violated the Constitution?
do I? No, I don't. I don't.
Why is that?
Because the vote that when the voters voted for that, the action that the Democrats took did not supply the money to actually pay the pay increases.
The action the Democrats took.
Correct. The enacting language for the constitutional amendment did not supply a way to pay the money. And what they left in place was still legislators having to vote to raise their own pay. They say that their intent was not to do that, but when I asked Democrats, will you put up votes if I put a bill on the floor that will fund the pay raises at what the Constitution now is directing us, they said no, they wouldn't. Well, they're not willing to vote for it. Why should they ask me to do that? So we'll let a court decide this, and if it is constitutional, members will get their pay increase, and the court will direct us to do it.
And then in that case, Mr. Speaker, you kind of have the best of both worlds, don't you? Because you've opposed this, but yet you can say, well, the court did it, and Democrats put it in place, and so the pay raise, none of my members voted for it. I mean, isn't that the politics
I've been
of it?
pretty vocal all along that I didn't think this was the right way to handle a pay increase. And I don't think the language that Democrats passed to accompany the constitutional amendment was sufficient to actually appropriate the money for the pay increase. It still required members to do it. So unfortunately, the flaw is on their side, and we'll get a court to interpret what this means. But at this point, I'm not willing to say that I'm going to approve the pay raise or that members should vote for their own pay raise. And members told me they weren't willing to do that. So I don't have a lot of choice in the matter.
During the hearing, the specter of this impasse lasting through the end of Dayton's term was raised. Do the citizens
when was
of
that raised?
That was raised during the hearing today,
Okay.
in the back and forth. Is that something that Minnesota voters really need to worry about?
There is a scenario where the court could uphold the line item veto, but then rule that the legislature is an essential service and a core function of state government and reinstate the funding. So there is a way to kind of split the baby, if you will, and we would consider that a huge win. I think what we can't have is a scenario where the governor, if he doesn't get his way, can line item veto funding for the legislature and hold them hostage. That grossly undermines the authority and power of what the governor, in his own words, calls a co-equal branch of government. So there was a scenario raised by the judge today where if the courts had made a decision that the governor didn't like, could he line item veto all of the judicial funding? And the attorney defended that, saying that would be okay. Well, no, it wouldn't be okay.
We said it would be distasteful.
Well, it's just as distasteful that they've done it now. It's no different. And the fact that the governor's attorney is willing to call it distasteful when it deals with the judicial branch, what was the word they used? Unsavory, not distasteful. Sorry. The fact that the governor's attorney is willing to say that it would be unsavory if it's the judicial branch, but somehow it's okay if you do it to the legislative branch. No, it's just as unsavory and it's just as wrong. And we're gonna fight him in court to right this injustice.
No, but in all fairness, Mr. Speaker, what he did say then in addition is that the funding can be asked for as a core function by the judicial branch, presumably a judge going before a judge and asking for a ruling the same way as you guys are doing.
So we're legislating through the courts. You know, we showed up on time, we did our job, we did it well. It's the governor now who has created this problem, and he's the one, frankly, who should figure out a way to fix this. If he didn't like those 5 provisions, he shouldn't have agreed to them. That's the question that I think you all need to ask the governor. If you didn't like these 5 provisions, why did you personally agree to them? And why do you think it's okay to ask the speaker or any other legislator to now change everything because you've changed your mind?
Yeah, well, he answered
That's
that-
unacceptable.
He answered that question and said he didn't want government shutdown.
Why did he agree to those provisions?
He said he didn't want government shutdown. I think that's what he said.
But it's okay to have legislative shutdown. Well, I disagree. Tom?
Legislating through the courts by asking a judge to allow this 90-day extension of funding? Shouldn't you try to get this worked out between you and the governor by July 1st?
Well, the governor has left us with no choice. You know, we didn't ask for this. We didn't create it. The governor brought this on his own, and we think it's wrong. So we have turned to the courts to resolve this, you know, what we have both described as impasse between the legislative and executive branches. My wish is that the governor would come to his senses and realize that he's wrong in this situation and offer a way of resolving the problem that doesn't make him go back on his own word. Part of this is making sure that we hold the governor accountable and that he show that he has enough integrity that when he makes an agreement that he sticks to it, that he stands by his word. What I've learned more than anything is apparently the governor's word can't be trusted because he did agree to all 5 of those provisions and now he wants to renegotiate those things. We don't find that acceptable and I think it doesn't show that the governor has a lot of integrity. Any other questions? Very good. Thank you.
Thank you, Mr.
Have a great day.